Excellencies, the state may have a right to diplomatic protection, Your Excellency, in order to bring up the claims of the national corporation. However, Your Excellency, it is a...
That is what they have done here.
Certainly, Your Excellency. However, Your Excellency...
So your locus standi point is nothing in it.
We beg to disagree, Your Excellency. We beg to disagree, Your Excellency. In the 1989 case of Electronica Sicula, decided by this very court, Your Excellency, what happened in that case, Your Excellency, there were two companies, United States companies owned by United States nationals, Your Excellencies, which were invested. Those are electronic companies, Your Excellencies, invested in Italy. And the government of Italy, Your Excellencies, expropriated these property. The International Court of Justice has stated that the customary norm of exhaustion of local remedies are so important that they cannot be easily dispensed with. Thus, Your Excellencies, the court, the International Court of Justice, did not proceed to hear the case of the United States because the companies did not exhaust all local remedies.
Agent, with the permission of the Chief Judge, due to the time factor, I would like you to proceed now to the adequacy of the compensation issue.
Thank you very much, Your Excellency. With respect to the adequacy of the compensation, Your Excellency, what is at issue here was whether or not national law should be the basis of determining what is adequate compensation. In this regard, Your Excellencies, we refer the attention of this court to paragraph 4 of the 1962 Declaration on the permanent resolution, or rather on the resolution on the permanent sovereignty of states over natural resources and economic activities, as well as Article 2, paragraph 2C of the Charter of Economic Rights and Duties of States.
So they are both General Assembly resolutions.
Yes, Your Excellency.
1962 and 1974.
Yes, Your Excellency.
Especially as regards CRDS, the
Yeah,
opinion
yes.
of both Opinio Juris and State Practice in 1974 is that CRDS, and even arguably 1962 permanent sovereignty, well, definitely CRDS is not customary international law. Can you address that issue now?
We beg to disagree, Your Excellency, that it is not customary international law. The only states, Your Excellencies, that question the customary status of the CERDS, Your Excellencies, are the industrial states, Your Excellencies.
That's exactly, but they are the powerful states. You know, you cannot adjure or you cannot ignore reality. State practice is based not on moral grounds or justice grounds, but on reality.
Yes, Your Excellency.
Physical as well as psychological.
However, Your Excellency, the entire international community is founded upon the general principle of sovereign equality of states. Regardless of whether or not these objectors, Your Excellencies, are the most powerful, Your Excellencies, by the mere fact that the generality...
But the developing countries themselves, post-1974 and post-1989, basically are not fully insisting on the CRDS. You know, you want to go back to the Hull formula of 1940s, or what?
We beg to, Your Excellency, we don't want to go back to the Hull formula of 1940. In this respect, Your Excellency, we note, Your Excellency, that the Hull formula is highly used by only 5 states. These are the United States, the United Kingdom, Germany, Belgium, and France, Your Excellencies. And these states, Your Excellencies, are the most highly industrialized in our world. Certainly, Your Excellencies, just because they are the most highly industrialized doesn't mean...
Right now, it is not Hull formula, but it is CRDS.
Yes,
that's
Your Excellency.
customary international law.
So, yes, Your
Is
Excellency.
that your submission?
Certainly, Your Excellency. It is supported by many of the opinion of the most highly qualified publicists in our generation, Your Excellency. Thank you very much, Your Excellency.
I think you had better wind up.
So, yes, Your Excellency. Your Excellencies, in the last 45 minutes that we have made our submissions, we have put forth that the government of Burgundan has violated our sovereignty and that they cannot excuse their acts either as a legitimate support to national liberation movement or an act of self-defense or an act of humanitarian intervention. We have also made submission, Your Excellency, that our exercise of jurisdiction over Ms. Tabilisi and her subsequent prosecution and conviction are consistent with international law, notwithstanding the fact that her abduction may be attributable to our state. Third, Your Excellency, is that Fudalan was culpably negligent in performing its special duty under the 1961 Vienna Convention on Diplomatic Relations. And lastly, Your Excellencies, our nationalization and compensation given to the Unicom telephone industry are in all respects consistent with international law.
Was the, can we go into reverse gear for a moment? Take you back to the point you were making about your entitlement to nationalize this particular country.
Certainly.
Was it a bona fide nationalization or was it a bona fide nationalization?
Your Excellency, it is a bona fide nationalization, Your Excellency.
I refer you to the case stated in the compromise. What you said when you acquired this company was that in view of recent events where our embassy was attacked, Donavale is forced to nationalize the company.
Certainly.
So it was not bona fide. It was actually spurred by collateral motive.
We beg to disagree, Your Excellency. Thank you very much, Your Excellency, for reading out page 5, paragraph 3, line 11 of the compromise. However, Your Excellency, let us note, Your Excellencies, that our nationalization did not occur in a vacuum. The nationalization must be viewed in light of the very precarious state of affairs that Donavale was in. Your Excellencies, there was an existing civil war between Donavale and the Agathan rebels.
You don't want to go into that now. Yeah. Because you go back to the question of who caused it all.
Which isn't helpful.
Your Excellencies, if you would like to ask me on that, I would very much gladly ask
we
you
have
on
already
that.
asked and received an answer which we have to accept as adequate.
In any case, Your Excellency, aside from that fact, we have the government of Burgundan invading our state, regardless of whether or not we started it, Your Excellencies. The fact is, there was invasion. And lastly, Your Excellencies...
I see, so everything else on the board is to be wiped out. All to be shaded away.
That is not what we are saying.
The whole history starts with the invasion.
Your
Is that your case?
No, Your Excellency, that is not what we are saying.
No background to this case. Time is extended by 2 minutes.
Yes, yes.
All right?
Yes, Your
So,
Excellency.
where do you start? Which is the starting point as far as you're concerned?
Of everything else, of everything that occurred, Your Excellency.
I mean, as to why we are here.
Certainly, Your Excellency. Everything started with Colonel Fatone's unauthorized bombing.
No, I think you've got to take it back a little bit further. Because something else happened before that.
Your Excellency.
There used to be a constitution which was suspended, isn't it?
Yes, Your Excellency.
Your head of state did that.
Yes, Your Excellency.
And that caused the civil war.
Yes, Your
And
Excellency.
that led to the attack on the Ngitans, who then fled and took refuge in Birmingham.
Yes, Your Excellency.
And then there was the kidnapping of this lady.
Indeed, Your Excellency.
So, who caused it off?
Your Excellencies, in that respect, may I refer...
You shouldn't even be here.
We beg to disagree, Your Excellencies. With respect to the legality of the suspension of the Constitution, first off, Your Excellency, may I please refer the attention of this Court to page 1 of the compromise on the provision, constitutional provision. It is expressly stated there, Your Excellency.
12 years had gone by. I also read it. 12 years went by. Your constitution has got a time limit of 10 years.
Yes, Your Excellency, but what we are referring, Your Excellency, what we are referring to is the constitutional limitation on the right to exercise secession. Your Excellency, it is expressly provided there that in order for Agatha to secede, there must be 70% vote of all residents in Agatha.
At that time, according to the compromise, there was a properly constituted state, which must include a judicial arm.
Your
Do you
Excellency.
agree with me? No. At the time.